Hi friends, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today. There is a big difference between a hearing where it's just the lawyers and a hearing where there are witnesses and testimony and all of that. Most lawyers understand that arguing before a trial judge involves getting things into the record and getting decisions made that you may want to later appeal. And to a certain extent, I think some of that's being done here in this status hearing that we're going to talk about today. I've got 4 cuts for you from that hearing, and we're going to talk about each one of them. It is interesting to me that Dick and Mr. Griffin approach this from a way that is a great deal different than how Creighton Waters approaches it. And it's also interesting to me that the judge who has been assigned is a female judge. And when I first listened to her, I thought maybe she was a male judge because her voice is very deep. But it's also apparent that she knows the law cold. And, so in some respects, when Dick and Jim and Creighton Waters are talking with this judge today, it is very similar to an appellate argument as opposed to an argument at a trial court. And that's just because of the nature of the judge. But there are a couple of things that Dick and Jim had to do. One of the things that they had to do was get in front of the judge their right to have an evidentiary hearing. And I think the judge would probably make a mistake if she didn't hold an evidentiary hearing. And so that matter really wasn't discussed too much. But the burden of proof and the standard of what has to be shown, that's really what's at issue. And the issue here is whether or not the jury was prejudiced in some way against Mr. Murdaugh by the comments made by the clerk. The prejudice, as I mention later on in this video, prejudice is not talking about bias the way we think of racial prejudice. It's the decision or the tendency to make the decision on the basis of emotion or some other factor as opposed to on the evidence. And I think the jury saw all the evidence, and I think they know pretty doggone well what actually happened here. The first cut I'm going to play for you is Jim Griffin arguing about whether or not you get an evidentiary hearing. If you watch him, he talks about essentially one case. He mentions a number of other courts, but he never talks about what those cases say other than the one case he relies on, basically, Reamer, has a presumption of prejudice, that if something happened, well, it must have been prejudicial. But that may not be an accurate statement of the South Carolina law. So cut 2 is going to be Creighton Waters arguing the cases and the very issue about prejudice. And then cut 3 will deal with our good friend Mr. Harpootlian talking about a novel theory of he ought to be able to ask each individual juror if maybe their minds were somehow poisoned by the comments made by the clerk. And I think the judge shuts him down fairly quickly on that. And then the last clip that I have is the judge basically saying, I'm not going to have any of the alternates testify. The only people I'm going to have testify are the people who participated directly in the verdict. Now, why would she do that? If she was really concerned about whether or not the statements were made, she'd have all of those people in there, right? But I think she understands and accepts that, yeah, the statements were made. In fact, I don't think the state really challenges that much. But the issue is whether or not it was prejudicial. And that's why she makes the ruling that she does here at the end. So let's get into these cuts right now.
Yes, thank you, Your Honor. The first issue that you've asked us to address is an evidentiary hearing necessary? And the answer to that question is very straightforward, is yes, under established case law in the Supreme Court, the Fourth Circuit, and the South Carolina Supreme Court under Reamer.
Okay, now he's talking about a case called Reamer, which arguably applies in some respects, but not necessarily in all respects.
A Reamer hearing is absolutely necessary where there has been credible evidence presented that there's been an improper third-party contact with the jury prior to their deliberations that frankly, whether it goes to the merits or not, a Reamer hearing is absolutely necessary. And
I think he's wrong about that.
The Court of Appeals decision in this case contemplated a Reamer hearing, and in a Reamer hearing, evidence is presented as to what outside influences that.
Now, how in the world you could ever, in any respect, say that the Court of Appeals thought that this would happen? The reason I have some suspicions about that is because when one of the things that appellate judges do is they try very hard to speak with the words they use and not imply things. They would much prefer to simply say them up front. And that's not what's happening here. And he's trying to read the appellate court's mind. And the judge that's on the bench is an appellate judge. And she may not appreciate that. But let's let him go ahead and finish here.
Were brought to bear upon the jury. We have, in our motion for a new trial, submitted affidavits of one deliberating juror, one alternate, and then another affidavit of a witness to an interview of an alternate, and all three statements are consistent, and in that they heard Ms. Hill, the clerk of court, prior to deliberations, and frankly before the defense put on their case. Ms. Hill instructed, do not be fooled by the defense. That's what the sworn statements say. And secondly, before Mr. Murdaugh took the stand, Ms. Hill advised one deliberating juror and two alternates, at least, watch his demeanor, which is an implication of, he's going to lie. And so then the question becomes, factually, did those contacts happen? And then, we proceed from there as to what the burden of proof is after that. But the threshold, are we entitled to evidentiary hearing? The law is crystal clear that we are.
Now, I'm not sure that it's necessarily crystal clear where you don't have a showing of prejudice. And now, let's listen to our good friend Creighton Waters discuss this. And you can tell that Creighton Waters is a lot more comfortable in front of an appellate judge than Mr. Griffin is. And watch how smoothly and articulately he handles this argument.
Mr. Waters? Sorry, Carl. Your Honor, and I'm going to walk through some of the cases in South Carolina that address this issue. But as Your Honor is aware, of course, when we deal with these issues, we have two types. We have internal misconduct, and our courts have been reluctant. Rule 606 says this as well, to delve into that unless there are concerns of fundamental fairness, like racism and things like that. And then there's external allegations of external influence and that sort of thing. And that's what we're dealing with here today. And to quote State v. Grovenstein, which is a 1999 case of the State Supreme Court, it cites Aldrin and Kelly and says, we have consistently held the defendant must prove prejudice.
And that's the key part of the argument here, because I don't think they can establish prejudice. I don't think Murdaugh can, because all of these people have said, yeah, we would still have voted guilty even if, Becky Hill hadn't said a word, because everybody could see the guy was lying. So when Creighton makes this argument here, what he's essentially saying is, Judge, the only thing you have to worry about is whether any of these 12 people who actually voted to convict are, in fact, the people who were prejudiced in some way or were biased in their decision some way by something that Ms. Hill said, and the evidence is going to be that that's not the case.
These sorts of claims. And if we walk through all of the case law, our court has been very careful, and as much said so in Aldred, which was an internal case, to sync the analysis and the standards between those two, and have been consistently held that the defendant has to show prejudice. It's their burden to do so. In Blake in 1992, the court held don't presume prejudice, and the test, of course, was whether or not the verdict was solely the product of honest deliberation or whether it was the product of outside influence. We go over to State v. Kelly. Of course, Your Honor concurred with Chief Justice Finney's dissent in that case, but in that case there was a pamphlet in the grand jury room. Clearly an external influence was alleged there. And ultimately in that case, the court held that the defendant failed to show prejudice from that particular external influence. In State v. Grovenstein, in this instance it was clearly external. There was an alternate who was present in the jury room and even took a preliminary vote with the jurors. So clearly an external influence, far more than is even alleged in this case. That juror was removed, curative instruction was given, but ultimately the court was very clear that we have consistently held the defendant must prove prejudice, again the burden being on the defendant. In Bryant, this was a capital case, one that argued way back when, and in that instance there was a police investigation, background investigation into death qualified jurors in a capital case. Clearly external. The trial court conducted an inquiry with questions submitted by the parties as well, and ultimately noted that it was the defendant's burden to prove actual bias on the part of the jury. In State v. Pittman, another case that I argued before, Your Honor, in that particular case there was a juror who had a conversation with his wife and with the bartender, and ultimately again the court held that the defendant failed to meet the burden of prejudice because the wife's comment was the defendant was not guilty, and the comment to the bartender took place after deliberations had begun. And then of course in Green in 2020, Your Honor just commented on that, and the court clearly held that the Romer presumption of prejudice doesn't apply here. And then, of course, went on to note that the defendant bears the burden of proving prejudice.
So you can see, and it's pretty clear here, that that's where he's going. And did you notice the way he said, the way he looped in there about a case that I argued in front of the court? In other words, meaning you, judge. And, you know, you, judge, you dissented with another judge in this other case that I was part of. I find it interesting that he is doing this because he knows the case law right, left, sideways, backwards, and forwards. And the guys to his immediate left, or if you're looking at the screen, to the right of him on the screen, they don't know the case law that well. They're taking snippets out of the case law to suggest that there's prejudice when in fact there may not actually be prejudice. But one of the key things here is whether or not the alternate jurors, who obviously have had some time to think about it, maybe they were upset that they didn't get to be on the jury, who knows, but two of them are the people that they want to call. So another thing that Dick Harpootlian did during the course of the hearing was he argued that if we show that these comments were made by the clerk, then we need to be able to ask the rest of the jurors if that question poisoned their minds. In other words, we need to get into the internal deliberations of the jury and listen to how the judge handled that. And it's sort of important to note that at one point, the judge here essentially told Dick that this wasn't the Senate, that he was, you know, in front of her and that she made the rules. But this is an interesting part where the guy doesn't know the case law and comes up with this ridiculous idea that we ought to be able to go to the bottom of the jurors' thought processes.
All right, and what are you saying that in courts for this procedure?
Well, I mean, for instance, if we prove to you that the court said, do not be fooled, or, you know, watch Murdaugh's testimony, watch the body language, inferring he was lying, he will be lying. One of the issues is if the juror who sat during the deliberations who said that the court said that, Did she discuss that with any other jurors? Did she infect the jury? Does this allow you to do that?
Well, you certainly, if you go to 606B, it gives you some guidance about that. It says, when inquiry into the validity of a verdict or indictment, a juror may not testify as to any matter or statement occurring during the course of the jury's deliberations or to the effect of anything upon that or any other juror's mind or emotions influencing the juror to assent or dissent from the verdict or indictment or concerning the juror's mental processes, except a juror may testify on the question whether extraneous, prejudicial information was improperly brought to the jury's attention, or whether any outside influence was improperly brought to bear upon any juror. Nor may a juror's affidavit or evidence of any statement by the juror concerning a matter about which juror would be precluded from testifying be received for these purposes.
So essentially what the court here is saying is, look, I'll let you ask if she heard these comments, but I'm not going to let you ask if those comments poisoned the minds of the other jurors that didn't hear them. We're going to talk just about the people who heard those comments. And it probably wasn't clear from that statement, but the judge did make it pretty clear a little bit later on. Now, this is at the end of the hearing, and she is announcing some of the rules and procedures for this evidentiary hearing that they're going to have. So listen closely here.
Before we proceed further, a few other things that you've asked about that I want to clarify before we then go forward with the more specific look at how witnesses will be questioned. First of all, how the jurors will be questioned. Everything will be done in open court. The
I love the
jurors
way the camera focuses on Murdaugh.
will be referred to by number. The court TV cameras, which are the ones used to film these proceedings, will not be allowed to focus on the image of the jurors as witnesses. And if there's some need to further obscure the way they are presented, we can talk about that. But they'll be examined right here in the courtroom as other witnesses would be. And I'll kind of look to the little bit of exchange we'll have with the attorneys for the jurors to see what we can work out about exactly how the jurors are presented. But everything will be on the record here in open court with measures taken to ensure the privacy of the jurors. No photographs would be permitted of the jurors or anything of that nature. And I believe if I announce that in advance, the press that are present,
Look at that worried look.
this
Oops, the stand's
proceeding
just
throughout
about up.
have been respectful of the judge's requests, and I'm very confident they will be in this matter as well. With respect to the alternate jurors,
Well, better go back to writing.
I will question only the jurors who sat and considered this case. So the alternate who was dismissed by the trial judge. That alternate did not participate in any way in the deliberations about this case. There's nothing that's been brought to my attention about anything the alternate might have done that was improper at all in terms of communications with fellow jurors.
Not what he wanted to hear there.
Nothing's been alleged in that regard.
His body language.
Our focus will be on the jurors that heard this case and not on either that alternate or any other alternate juror.
There you have it. And it's pretty interesting to me how this all more or less devolves down to whether or not anybody was actually prejudiced. Now, that was exactly the position that the state took. And according to the state, all of these people said they would still vote for conviction. So this may be an exercise in ridiculousness. Now, she did lay out some ground rules about how the jurors were not going to be photographed and they're not going to be on video. They're going to have the courtroom open. The lawyers who represented the jurors wanted the courtroom to be closed, but the court did not do that. Then they didn't want to hold it in camera. She's going to make sure that the cameras for court TV don't focus on the individual jurors when they're testifying. And I suspect that in spite of Dick being one of those people who likes to filibuster, that these examinations are not going to go particularly long, and that Creighton Waters, his entire cross-examination is going to be, did it affect the verdict? No. And, then he's going to sit down because that's how he would win. He simply has to show there's no prejudice here. It will be interesting to see what comes out of the hearing. I don't think that the evidentiary hearing is going to do Mr. Murdaugh a great deal of good. I think all of the jurors are very comfortable with the decision they reached. I think many of them felt pressured to come in and say, well, yeah, the clerk did say a couple of things. And of course, Jim and Dick have blown that up into a major issue when I don't really think that it is. But Murdaugh has money. He's fighting these cases. And of course, Harpootlian and Griffin have a reputation to uphold, and that's why they're doing what they're doing. I hope that at the end of the day, justice is done. If there was influence in the jury room and it did cause him to get convicted unfairly, then obviously what we want is we want to have a new trial and have him convicted fairly, assuming, of course, that the next jury would actually convict him fairly. And he certainly can't run from the financial crimes because he's already been convicted of those. Those are, if he decides to testify, anything he says, he can be impeached with the information of his prior crimes. So there's a lot there that, it's almost a losing proposition to have another trial because it'll go on and on and on, just like the last one did, and the result will most likely be the same thing. Juries very rarely tend to make a different decision unless there's a huge change in the amount and type of evidence that's presented. And given the way this case has been thoroughly documented on YouTube and court TV and everywhere else, I think it'd be really, really hard to pull one over on a later jury. But that's what I have for you today. Thank you so much for watching. If you have the opportunity today, do something nice for someone. And, my wife wasn't feeling real good today, so I made her some chicken soup. It's always a good thing when you're not feeling good to have a little chicken soup. So have a terrific day and come down here and catch me at the beach next time. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.